Hello dear students, the topic for our today's session is registration of partnership firms. Let us begin with the introduction. You might be aware that one of the forms in which business can be carried on is partnership, where two or more persons join together to form the partnership and run the business. In order to govern and guide partnership, the Indian Partnership Act 1932 was enacted. In human relations, often misunderstandings crop up. If any misunderstanding crops up in a partnership amongst its partners, the continuity of the partnership may become doubtful. Since public at large would be dealing with the partnership as customers, suppliers, creditors, lenders, employees, or in any other capacity, it is also very important for them to know the legal consequences of their transactions and other actions in relation with the partnership, where no one person is the owner of the business and therefore exclusively responsible. The law relating to partnership in India, which is contained in the Indian Partnership Act of 1932, is concerned partly with the rights and duties of partners between themselves and partly with the legal relations between partners and third persons, which flow or are incidental to the formation of a partnership. Thus, the Act not only determines the rights and duties of a partner in relation to the partnership business, but also against other partners. It clearly establishes the position of a partner as well as partnership firm vis-a-vis third parties in legal and contractual relationships arising out of and in the course of business of the firm. It may be described as a branch of law relating to the principal and agent, since every partner is in contemplation of law, the general and accredited agent of the partnership. Now, let us know what is partnership. Partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any one of them acting for all. It therefore follows that a partnership consists of three essential elements. First one, it must be a result of an agreement between two or more persons. Second, the agreement must be to share the profits of the business. Third one, the business must be carried on by all or any of them acting for all. All these essentials must coexist before a partnership can come into existence. Example, a manager, as a part of his remuneration, may be given a share in profits of the business. He does not thereby become partner. Now, let us know in detail few essential elements of partnership. We shall now consider the aforestated essential elements one by one. Agreement. You have just observed that partnership must be the result of an agreement between two or more persons. You should note that it can arise only from a contract and not from status. That is why a partnership is distinguishable from a Hindu undivided family carrying on a family business. The reason is that as a result of the peculiarities of Mitakshara school of Hindu law applicable to joint families, a male child of a Hindu acquires an interest in a family business even in the absence of an agreement in that behalf, whereas partnership is a creation only out of mutual agreement. Thus, the nature of the partnership is voluntary and contractual. An agreement from which relationship of partnership arises may be express. It may also be implied from the act done by partners and from a consistent course of conduct being followed, showing mutual understanding between them. It may be oral or in writing. Sharing profit of business is one essential element. In this context, we will consider two propositions. First, there must exist a business. For the purpose, the term business includes every trade, occupation and profession. The existence of business is essential. The motive of the business is the acquisition of gains, which leads to the formation of partnership. Therefore, there can be no partnership where there is no intention to carry on the business and to share the profit thereof. For example, co-owners who share amongst themselves the rent derived from a piece of land are not partners because there does not exist any business. Similarly, no charitable institution or club may be floated in partnership. A joint stock company may, however, be floated for non-economic purposes. Secondly, there must be an agreement to share profits. For example, X and Y buy certain bales of cotton which they agree to sell on their joint account and to share the profits equally. In these circumstances, X and Y are partners in respect of such cotton, but an agreement to share losses is not an essential element. However, in the event of losses, unless agreed otherwise, these must be borne in the profit sharing ratio. Another important element is business carried on by all or any of them acting for all. The third requirement is that the business must be carried on by all the partners or by any one or more of the partners acting for all. This is the cardinal principle of the partnership law. An act of one partner in the course of the business of firm is in fact an act of all the partners. Each partner carrying on the business is the principal as well as the agent for all the other partners. You should therefore note that the true test of partnership is mutual agency rather than sharing of profits. If the element of mutual agency is absent, then there will be no partnership. Sharing of profits is only prima facie evidence which can be rebutted by stronger evidence. Thus, this prima facie evidence can be rebutted by proving that there is no mutual agency. Now, let us know one important fact, that is true test of partnership. You must have understood that sharing of profits is an essential element to constitute a partnership, but it is only a prima facie evidence and not conclusive evidence in that regard. The sharing of profits or of gross returns accruing from property by persons holding joint or common interest in the property would not by itself make such persons as partners. Although the right to participate in profits is a strong test of partnership, and there may be cases where upon a simple participation in profits there is a partnership, yet whether the relation does or does not exist must depend upon the whole contract between the parties. Where there is an express agreement between partners to share the profit of a business and the business is being carried on by all or any of them acting for all, there will be no difficulty in the light of the provisions of section 4 in determining the existence or otherwise of partnership. But the task becomes difficult when either there is no specific agreement or the agreement is such as does not specifically speak of partnership. In such a case, for testing the existence or otherwise of partnership relation, section 6 has to be referred. According to section 6, regard must be had to the real relation between the parties as shown by all relevant facts taken together. The rule is easily stated and is clear, but its application is difficult. Cumulative effect of all relevant facts such as written or verbal agreement, real intention and conduct of the parties, other surrounding circumstances, etc., are to be considered while deciding the relationship between the parties and ascertaining the existence of partnership. The receipt by a person of a share of the profits of a business, or a payment contingent upon the earning of profits or varying with the profits earned by the business, would not by itself make him a partner with the persons carrying on the business, particularly when such share of payment is received by the persons like a lender of money to persons engaged or about to be engaged in any business, or a servant, example manager of a firm, or agent as his remuneration, or widow or child of a deceased partner, or a previous owner of partner of the business as the consideration for the sale of the goodwill or share thereof. Existence of mutual agency, which is the cardinal principle of partnership law, is very much helpful in reaching a conclusion in this regard. Each partner carrying on the business is the principal as well as an agent of other partners. So, the act of one partner done on behalf of firm binds all the other partners. If the elements of mutual agency relationship exist between the parties constituting a group formed with a view to earn profits by running a business, a partnership may be deemed to exist. Thus, as laid down in Cox v. Hickman, that the true test of partnership is agency and not the sharing of profits. Now, let us know distinction between partnership and firm. Persons who have entered into partnership with one another are called individual partners, and collectively the name under which the business is carried on is called the firm name. Partnership is merely an abstract legal relation between the partners. A firm is a concrete thing signifying the collective entity for all the partners. Partnership is thus that invisibility which binds the partners together, and firm is the visible form of those partners who are thus bound together. Now, let us know what is partnership deed. The agreement creating a partnership may be implied or expressed. However, to avoid future disputes, it is always better to have the agreement in writing. Such an agreement in writing is called a partnership deed. A partnership deed is a document which contains the terms and conditions of the partnership. It can be written in any form and it should be signed by each partner personally or through his agent. The partnership deed should also be stamped properly as per the Stamp Act of 1889. If the firm is registered, the deed must be registered with the registrar of firms. The deed may be modified or altered from time to time with the consent of all the partners. Now, let us study the registration of firms. The provisions relating to registration of firms are being covered under the sections 56 to section 71 of Indian Partnership Act 1932. Registration means to get the partnership firm registered with the registrar of firms. Before the enactment of the Partnership Act, there was no provision for the registration of the partnership firms in India, and as such, the third party faced difficulty to prove the existence of partnership and claim against all the members of the firm. Thus, the provisions relating to the registration were included under the Indian Partnership Act 1932. This present act made the registration optional entirely at the discretion of the partners. Under the act, it is not necessary for every partnership firm to get it registered, but an unregistered firm suffers from a number of disabilities. The registration of a firm may be affected at any time by sending by post or delivering to the registrar of the area in which any place of business of the firm is situated or proposed to be situated. A statement in the prescribed form. It is not essential that the firm should be registered from the very beginning. When the partners decide to get the firm registered, as per the provisions of section 58 of Indian Partnership Act 1932, they have to file the statement in the prescribed form. The statement must be accompanied by the prescribed fee stating the firm's name, the principal place of business, the name of its other places of business, date of joining of each partner, names in full and permanent addresses of the partners, and the duration of the firm. The aforesaid statement is to be signed by all the partners or by their agents specially authorized in this behalf. Each partner so signing, it shall also verify it in the manner prescribed. When the registrar is satisfied that the mentioned provisions have been complied with, he shall record an entry of this statement in the register called the Register of Firms and shall file the statement. Subsequent alterations, as like alterations in the name, place, constitution, etc. of the firm that may occur during its continuance, should also be registered. Now, when is the registration complete? When the registrar is satisfied that the provisions of section 58 have been duly complied with, he shall record an entry of the statement in a register which is called as the Register of Firms and shall file the statement. Then he shall issue a certificate of registration. However, a registration is deemed to be complete as soon as an application in the prescribed form with the prescribed fee and necessary details concerning the particulars of partnership is delivered to the registrar. The recording of an entry in the Register of Firms is a routine duty of registrar. Registration may also be affected even after a suit has been filed by the firm, but in that case it is necessary to withdraw the suit first and get the firm registered and then file a fresh suit. Now, registration of alteration. After registration, a firm may have changes in its particulars from time to time. If any change occurs in the constitution of the firm, then such changes must be informed to the registrar of the firms. The changes could be with relation to like change in firm name and principal place of business. Change in firm name and principal place of business requires almost a new registration. In such cases, a new application form containing changed particulars is to be sent to the registrar of firms along with the prescribed fees and duly signed and verified by all the partners. The registrar will then record the change in the register according to the new form submitted. There can be a change regarding closing or opening of branches. When the firm opens new branches or closes an existing branch, the necessary information needs to be supplied to the registrar of firms by any of the partners or an agent of a firm by sending a notice of change to registrar of firms along with the prescribed fees. The registrar will then note down the necessary changes in the register. This does not apply to the principal place of business. There can be a change in the name or permanent address of any partner. When the partner of a registered firm changes his name or permanent address, then the information needs to be furnished to the registrar of firms by any of the partners or an agent of firm by sending a notice of change to registrar of firms along with the prescribed fees. There can also be a change in the constitution of firm like new partner joining or existing partner retiring. In case of reconstitution of the firm, that is when a new partner joins or an existing partner retires, then in such cases, a notice regarding the same along with the date of reconstitution should be furnished to the registrar of firms by new, continuing or retiring partner of firm by sending notice of change to registrar of firms. Sometimes there may be changes regarding a minor partner's decisions, whether to continue or leave on becoming a major. Sometimes a minor is admitted to the benefits of the firm. Such a minor can, after becoming a major, decide to leave the firm or may opt to remain in the firm. Then in such case, any decision made by him is to be notified to the registrar of firms, who shall record the same. The notice can be given by such partner or his authorized agent. Now, in case of dissolution of firm, states that when a registered firm is dissolved, then the notice of dissolution is also to be sent to the registrar of firms by any person who was a partner of the firm immediately before the dissolution. Now, let us study few rectification of the mistakes if already made. If there is any mistake in the documents filed with the registrar, all the parties who have been signatories to such documents shall file an application to the registrar for rectification of such a mistake. Thereupon, the registrar shall rectify such a mistake in the register of firms. Amendment of register by order of court. When a court decides any matter related to a registered firm, it may direct the registrar to make any amendment in the register of firms relating to such a firm, and upon such direction, the registrar shall amend the entry accordingly. Inspection of register of firms. The register of firms, all statements, notices and intimations filed with register of firms shall be open to inspection by any person subject to payment of prescribed fees. Now, let us study grant of copies. Any person on application can obtain copy of entry or portion thereof in register of firms subject to again payment of the prescribed fees. Now, what can be the consequences of non-registration? Under the English law, the registration of firms is compulsory. Therefore, there is a penalty for non-registration of firms. But the Indian Partnership Act does not make the registration of firms compulsory, nor does it impose any penalty for non-registration. However, under section 69, non-registration of a partnership gives rise to a number of disabilities which we shall presently discuss. Although registration of firms is not compulsory, yet the consequences or disabilities of non-registration have a persuasive pressure for their registration. These disabilities briefly are: no suit in a civil court by firm or other co-partners against third party. The firm or any other person on its behalf cannot bring an action against the third party for breach of contract entered into by the firm, unless the firm is registered and the persons suing or have been shown in the register of firms as partners in the firm. There is no relief to partners for set off of claim. If an action is brought against the firm by a third party, then neither the firm nor the partner can claim any set off if the suit be valued for more than 100 or pursue other proceedings to enforce the rights arising from the contract. Third one, aggrieved partner cannot bring legal action against other partner or the firm. A partner of an unregistered firm or any other person on his behalf is precluded from bringing legal action against the firm or any person alleged to be or to have been a partner in the firm, but such a person may sue for dissolution of the firm or for accounts and realization of his share in the firm's property where the firm is dissolved. There are certain exceptions. Non-registration of a firm does not, however, affect the rights like: first one, the right of third parties to sue the firm or any partner. Second, the right of partners to sue for the dissolution of the firm or for the settlement of the accounts of a dissolved firm or for the realization of the property of a dissolved firm. Third one, the power of an official assignees, receiver of court, to release the property of the insolvent partner and to bring an action. Fourth one, the right to sue or claim a set off if the value of suit does not exceed 100 in value. Let us now examine some cases. A and Company is registered as a partnership firm in 1970 with A, B and C as partners. In 1971, A dies. In 1972, B and C sue X in the name and on behalf of A and Company without fresh registration. Now, the first question for our consideration is whether the suit is maintainable. As regards the question whether in the case of a registered firm whose business was carried on after its dissolution by death of one of the partners, a suit can be filed by the remaining partners in respect of any subsequent dealings or transactions without notifying to the registrar of firms the changes in the constitution of the firm. It was decided that the remaining partners should sue in respect of such subsequent dealings or transactions even though the firm was not registered again after such dissolution and no notice of the partner was given to the registrar. The test applied in the cases was whether the plaintiff satisfied the only two requirements of section 69 of the Act, namely, the suit must be instituted by or on behalf of the firm which had been registered, and second, the person suing had been shown as partner in the register of firms. In view of this position of law, the suit is in the case by B and C against X in the name and on behalf of A and Company is maintainable. Now, in the discussed illustration, what difference would it make if in 1972 B and C had taken a new partner D and then filed a suit against X without fresh registration? Where a new partner is introduced, the fact is to be notified under section 63 subsection 1 of the Act to registrar, who shall make a record of the notice in the entry relating to the firm in the register of firms. Therefore, the firm cannot sue as D, the new partner's name has not been entered in the register of firms. It was pointed out that in the second requirement, the phrase person suing means persons in the sense of individuals whose names appear in the register as partners and who must be all partners in the firm at the date of the suit. To conclude, in this topic we have studied the introduction about partnership, the partnership form, essential elements of partnership, the partnership deed. We also discussed about the registration of a partnership firm, registration of alterations related to the firm, rectification of mistakes during registration and consequences of non-registration, etc. Thank you so much.